Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So previously I did a video on the Queen and Cowan looking at the issue of plastic gun cases. Now I said I was going to come back and do the rest of this case, and that's what I plan to do today because this is a really interesting case. There's a lot going on to it. In particular, one issue is with respect to section 105 of the criminal code. That's the reporting of firearms that have been lost or stolen. There's also a lot here about the standard of care for careless storage. This video should also answer a question a lot of you had, which was, what happened to Mr. Cowan's guns? Where did they go? Well, Mr. Cowan's got a pretty good theory about that, and I couldn't cover it last video just for time, but we'll get to it this time. So, looking at sort of some additional stuff, I'm going to be retreading a bit of material from the previous video, but I'm really going to be focusing in a different direction this time. So we see he's charged with the careless storage, but also any loss or theft of a firearm must be reported with reasonable dispatch. So Joey Cowan, who they're going to just call Cowan going forward, was the owner of 8 legally acquired and registered restricted and non-restricted firearms, which he stored in his home. Those firearms were trigger locked and stored separately from any ammunition in storage cases that were padlocked. All of the cases were stored behind Cowan's computer desk downstairs in his home, where there were upwards of 6 children under the age of 18, as well as a house guest. The only time Cowan checked up on his firearms was when he retrieved them to go to a shooting range. The last time he did this was on March 11th, 2015. So I've got house guest underlined here because the house guest is going to be a little bit of an interesting story. So on June 10th, 2015, the authorities in Winnipeg received information that one of Cowan's restricted firearms was found in British Columbia. On June 17, 2015, a search warrant executed on Cowan's home revealed that all 8 of his firearms were missing. None of them had been reported lost or stolen. The only thing found was some ammunition and the keys to the cases and trigger locks that had been stored in the combination locked safe. Cowan's position is that he was unaware his firearms were missing. It is undisputed that he was both upset and concerned by their absence. The only items still found in Cowan's home were the keys to the trigger locks and padlocks, as well as the ammunition that was stored in a safe and in a combination lock storage case. Though Cowan was shown this ammunition case unlocked, it is unclear how that came to be and whether that might have occurred during the search. So he was charged with careless storage, but also with failure to report the loss of a firearm as required under section 105(1)(a) of the code. So the Crown's position, of course, is that he's guilty, because if the Crown's position wasn't that, they could just drop one of the charges or ask the court to dismiss it at this stage. She also submits that Cowan's choice of storage location, given the circumstances present within his home and the lack of regular monitoring of his firearms, likewise made him guilty of careless storage. So I'm not covering the case issue. We already know that the court found that the cases were fine, but now we're going to cover a bit about the location that he was storing them at, as well as the reporting issue. As for the charge of failing to report, the Crown submits that because of Cowan's careless storage, and in particular his lack of regular monitoring of the firearms, the loss of the firearms was undetected such that he did not report their loss with reasonable dispatch. As such, he argues that he is also guilty under section 105(1)(a). So look at what the Crown's argument is here. Not only do you have to report them lost or stolen, but that you have to constantly check them to see if they're there. Now, if you've got a substantial collection, that could actually be a bit of a big deal, because going through, there are people out there who've got hundreds of firearms. The notion that you could go through and check all of them off on a list might be a little problematic. You might notice if all of them were gone, but if one of them, I don't know. So we'll have a look at what the court says about that. Defense counsel argues that this court should find Cowan not guilty of both charges. He says that Cowan's storage practices not only comply with all legal requirements, they are consistent with the standard practice of many firearm owners. He also submits that Cowan cannot be found guilty under section 105(1)(a), as he did not know about the loss or theft of his firearms and therefore could not report it. So the Crown's theory is that he was supposed to know. He ought to have known that these were missing, and therefore he's guilty. Defense theory is he didn't actually know, and so we can't find him guilty. This is going to be a subjective versus objective mens rea issue. So let's have a look at that. I covered that somewhat before in my case of the Queen and Zora, but let's have a look a little further. So the court will then need to assess the competing expert opinions to determine whether or not, based on that evidence, the Crown has proven the offense of careless storage against Cowan. As for the offense of failing to report the loss of a firearm, this requires both a legal determination of the mens rea requirement under Section 105(1)(a) and a determination of whether, based on the court's factual findings, the Crown has proven the offense against Cowan beyond a reasonable doubt. And they note, as will be explained below, I find that the Crown has failed to prove the offenses of careless storage and failure to report beyond a reasonable doubt. Again, I love when the court tells us where we're going before we get there. So I'm skipping over some of the background here. He was in a relationship. Now that's broken up, partially because of these court processes. A court process is always very stressful on everyone involved, and his wife was not terribly thrilled by what happened, from what I can gather. So the firearms thus stored, which is in the plastic cases, I'm not going to go over that just to keep the video down, but you can look at the previous video if you want to know about the case issues. So the firearms thus stored were hidden in Cowan's home, consistent with where he legally registered them. The evidence is that all firearms were hidden in the basement behind Cowan's computer desk and storage unit. That desk and storage unit were located in the far left corner of the basement relative to the basement stairs and a television sitting area. Though the desk and storage unit were visible from the stairs and the sitting area, the bottom portion of the desk was obscured by a significant pile of personal effects, furniture, and building equipment. To access and see the entire unit and desk, it was necessary to walk around that pile. So, not the cleanest place, but my place isn't the super cleanest either. But it looks like this was sort of fairly tucked away. It's not super obvious where these were. It wasn't like he was leaving these cases sort of sitting out in his living room. There's some description again of the cases, but the evidence before this court is that Cowan was the only person in the house that went near the storage unit and desk. Though Cowan went downstairs and in and around the desk and storage unit relatively frequently, it was not his practice to ascertain that the firearms were still stored in their hiding place. He would only check up on them when he retrieved them to practice shooting at the gun range. Passcode records from Extreme Gun Shooting Center indicate that Cowan went to the range 6 times in September 2014, 3 times in October 2014, 1 time in November 2014, 2 times in December 2014, and 3 times in March 2015. The last time Cowan attended the range and checked on his firearms was March 11th, 2015. So they've got that. I'm not sure if that was the defense that provided that, or if that would have been the Crown subpoenaing those records. If you're wondering, when you give the CFO the details about which range you're a member of, that means that they have that information and then they can go looking into it. So just something to be aware of. Sometime between that date and June 2015, when one of Cowan's restricted firearms was located in British Columbia, the firearms were removed from Cowan's basement. So we have the circumstances surrounding the storage of the firearms. Between September 2014 and June 2015, several events were occurring in the Belanger-Cowan household. In addition to the 6 children, Cowan was undertaking extensive renovations throughout the home, including the basement. As he was not working, other than to attend an occasional speaking engagement, he spent most of his days doing these renovations. I'm wondering what sort of speaking engagement he's got that counts as work, but I don't know. That's not terribly important. I'm just curious. Added to this was the presence of a house guest, the guest, who Cowan had met at the methadone program he attended. So note that that wasn't in and of itself disqualifying to him having a license. However, when you think about, as a firearm owner, who you want to bring into your home, I don't know, maybe he should have vetted this particular individual a little better, because it sounds like Mr. Cowan and the house guest, who they don't name, had very different outcomes from the methadone treatment. We'll see a little bit more on that. The Crown submits that the presence of children and the guest in the home necessitated better storage practices by Cowan. She says that the children had full and unsupervised access to the basement, which created a potentially dangerous situation, necessitating a different storage location for the firearms. She also says that given Cowan's concerns about the guest, which will be detailed below, he should have checked regularly on his firearms to ensure their whereabouts. Defense submits that the children would never have had access to the firearms, and regardless of any concerns Cowan may have had about the guest, his storage practices were in compliance with the law. Given these differences in position, it is important to determine the circumstances surrounding the children and the guest in the home, as well as who knew about the location of the firearms. The adequacy of these storage cases will also be dealt with under the heading, the experts. So, circumstances of the children in the house. Given the custody arrangements for Belanger's and Cowan's respective children, there was a varying number of children in the home at one time. At the relevant time, the two youngest and two middle children each shared a bedroom. Cowan was renovating the basement to build 2 bedrooms for the eldest children, a bathroom and a laundry room. Cowan testified that most of the downstairs renovations were completed in January 2015, such that the 2 eldest children were able to move into them at that time. Cowan testified that during the first part of the downstairs renovations in the fall of 2014, the children were not allowed downstairs for safety reasons. Once the majority of those renovations were done, he did allow the children to play downstairs, but only for approximately 2 weeks as they were creating a mess and damaging building materials. He did not agree to allow them back downstairs until about the spring of 2015. Belanger at first testified that the children were generally always allowed access downstairs, as there was little other room in their modest home. She added that there were some intermittent times when the basement was off limits due to the renovation materials, but that other than those times, the children would play the Wii and watch television. In cross-examination, however, Belanger conceded that the 2 middle children generally spent time in their own rooms, and the younger ones were not allowed downstairs without supervision. As for the older children, she testified that she believed they moved downstairs at the beginning of 2015. Photographs of the basement taken during the June 17, 2015 search show a basement living area where there is a couch, a chair, a coffee table, and a television. The area is tidy but shows a water bottle and a television remote on the coffee table, consistent with recent usage. There is, however, no evidence as to who would have left those items there. Further, no toys were depicted. So that's going to be a big deal, because if there were toys there, especially toys consistent with young kids, that would suggest that the kids are there a lot. Given this evidence, I accept that the children were rarely allowed access to the basement during the relevant time, and that when they were allowed access, the young children were generally supervised. Though not clearly canvassed in the evidence, I infer, given the downstairs bedrooms for the eldest children, that they were not supervised. There is, however, no evidence that any of the children ever saw the firearms, knew of their existence in the home, or ever had them in their possession. So this is a bit of a gap in the evidence. The Crown could potentially have called the children as a witness. Now that might have been something that they avoided doing just to avoid causing further family stress, because if you're getting the kids to testify against mom and dad, it's something that they generally try to avoid unless the allegations are something along the lines of mom and dad having done something to the kids. The Crown has more considerations than just getting a conviction. And so if they didn't call these kids as a concession to sort of family unity, I can't fault that. In fact, I think that's praiseworthy. Although here we see that the lack of that evidence does hurt the Crown's case. The Crown's case would have been strengthened here if they'd been able to call these kids as witnesses, and the kids say, oh no, we play down there all the time. Mom and dad never pay attention to us. We just don't know here. But the court is commenting on a gap in the evidence. Generally, a gap in the evidence like this tends to favor the defense. And I say tends to because sometimes it might not support a defense that the defense is themselves arguing. But because the Crown bears the burden of proof, generally, if the court doesn't know what's happening, it's better for the defense, which is another reason why you don't want to talk to the police if you are getting interviewed or the like. Now we get to the fun part of this case, which is the circumstances of the guest in the house, because this is really where things start to go off the rails. Sometime between the summer and fall of 2014, the guest was also staying in the Cowan Belanger home. The evidence about exactly when and for how long is not clear. The evidence is also not clear about how much of a concern the guest was for Cowan and Belanger as a result of some allegedly dishonest behavior. Cowan's evidence is that he met the guest in about 2014 at the methadone program. When he learned the guest had nowhere to live, Cowan offered to have him stay at his house. Now, I'm guessing that the guest may have had nowhere to live because he may have burned a lot of bridges. Sometimes when people are deep in the throes of an addiction and they may not be trustworthy simply because while they're dealing with an addiction, while they're in the throes of it, they may be sort of driven by that need. But that might, and I'm just just guessing here, but that might have been one of the reasons why this guest had nowhere else to go. So Cowan testified that the guest first stayed with them in the fall of 2014 when Cowan and Belanger took their family on a 2-week trip to visit Belanger's family. Cowan testified that this would have happened in about October 2014. That's a lot of trust. Somebody who you met at some program, but you're not really going to know somebody that well in that period, and leaving them alone in your house when you're away, that's a lot of trust. Belanger, on the other hand, testified that she believed it was in July or August 2014, given that it was a family trip and the children would have likely needed to be out of school. Cowan testified that the guest slept in his and Belanger's bedroom during this time. There was no evidence from Belanger on this point. Cowan testified that upon their return from the trip, the guest left, but returned in about November 2014 as he still had nowhere to live. He stayed until just before March 11th, 2015. So they're doing this guy a solid, giving him a place to stay, but we'll see how that works out for him here. Belanger's evidence differed on this point. In addition to her evidence that the guest stayed with them beginning in about July or August 2014, she testified that she believed he left before Christmas, deducing that this must have been the case as she could not remember buying a gift for him, something she likely would have done. She did explain, however, that she generally was not good with dates or recollecting what happened or when. So she's got a bit of a shaky memory here. That's never helpful for the Crown or for whoever's relying on the witness if they can't remember key details and where they're needing to sort of infer or guess what happened. It's not the greatest. Cowan agreed with Belanger that the guest was not at their home during Christmas, but testified that was because he had asked the guest to leave for that period so that Cowan could spend the Christmas holidays alone with his family. The guest then returned and left again sometime before March 11th, 2015, when Cowan last saw his firearms. During the second stay, the guest slept on the downstairs couch by himself until the children moved downstairs. No questions were asked of Belanger about the guest's sleeping arrangements or his general functioning in the home. Cowan's evidence is that the guest turned out to be a very dishonest individual. He testified that the guest betrayed his trust on multiple occasions, characterizing him as a liar and someone who took advantage of him and Belanger and put his family at risk. Cowan testified that the first instance of dishonesty was in relation to their van. He and Belanger gave money to the guest to have their van repaired. Despite taking the money and telling them he had taken care of it, it appeared that no repairs were ever done and that the guest had simply pocketed their money. He also testified that the guest left drugs in their van, and when it was impounded, the guest asked him to provide a false name to police. Cowan also testified that he personally noticed items missing from his house, such as money and belongings, and that the guest was being dishonest about where he was spending his days. He testified that he did not share these incidents with Belanger, but that as a result of the guest's behavior, he personally decided to ask him to leave, as he was no longer prepared to potentially have his family put at risk by an individual who was so dishonest. He explained that his departure was fairly confrontational, and he asked him to open his bags. Inside were several of Cowan's personal belongings. So we see that the guest here was maybe not as successful at the methadone treatment, and it seems from Cowan's evidence, assuming that we find it credible and the court doesn't really find a reason to disregard it, although we'll get to how they deal with the evidence in a bit. But it seems like there may have been an ongoing addiction, this sort of theft behavior. But this is not somebody I'd want in my house, and especially as a firearm owner, I think I would have thrown him out a lot sooner. But we all have different standards, and the standard, of course, is not going to be perfection. We'll get to what the standard is. This testimony appears to be contradictory to Cowan's June 17, 2015 statement to the police. In that statement, Cowan advised the police that the guest's departure was precipitated by a phone call from the guest parole officer telling them that they should have him leave immediately and that Belanger was livid. When this contradiction was pointed out to him, Cowan testified that the parole officer had called after, not before the guest's departure, and that it was to insist that they not allow the guest back in. The parole officer was not called by the Crown. Again, you see the court commenting on a gap in the evidence. I bet the Crown would have liked to have had the parole officer there just to clear this up, but they didn't. So Cowan testified that when he kicked the guest out, he asked for the house key, only to be left with the impression that it had been left in their impounded vehicle. was only later, when he got the vehicle back from impoundment and he realized the house key was not there, that he decided to change the locks to the house. However, as he was busy, this did not happen for approximately 6 weeks, roughly around the end of April 2015. In the meantime, the guest had continued to come to the house when only the children were home. It is unclear when Cowan learned of this. When questioned in cross-examination about the time it took him to change the locks in these circumstances, Cowan added that the house was alarmed, but then went on to explain that the alarm was not always set. This information about the alarm, as well as his evidence about not finding his house keys in the impounded vehicle, were not provided to the police in his June 17, 2015 statement. Let's talk a little bit here about the statement, because clearly he gave a statement to the police. Now, that statement that he gave to the police would have been one where he's offering his explanation and he's trying to defend himself. You see how it's hurting him here? You see how even though he would have been giving a statement where he's telling his side of the story and trying to explain, this isn't my fault, here's what's going on, the fact that he didn't say things to the police back then is now hurting him. And he might have had some time to think about things and remember details better, but your statement and your testimony in court, no matter how honest you are never going to match, because memory is fallible. You're just not going to have perfect recollection between the two circumstances. So the statement that he gave where he was trying his best to, explain his side of the story and, assuming that he's trying to be truthful, I'm assuming that he's doing his best to tell the police the truth here. This statement does not work out for him. And this is very common. Do not give a statement to the police. Had he talked to a lawyer, the lawyer would have said, don't do this. This is a bad idea. But he did. And we can see it's hurting him here. Belanger testified to having no knowledge of any issues with the guest. On cross-examination, she did, however, acknowledge several of the situations Cowan mentioned in his testimony. She conceded that their vehicle was impounded after they let him use it. She also conceded that they gave him money to fix their van, but that it still seemed like it had not been repaired, so they assumed he had pocketed the money for himself. She also acknowledged that the guest's parole officer called the house and spoke to Cowan, though she had no knowledge of what that conversation was about. No evidence was elicited as to when these events occurred. You can see that the communication in this relationship is fantastic. I wonder why the relationship broke down. Because I will tell you, if we had a house guest and their parole officer called me to say, keep them out of your house, this person is is bad news, I would have mentioned that to my wife. And I don't even have kids. So this would have been something that would have come up because it's kind of important. Their relationship issues are another issue, but it does affect the case here because the court's going to have some trouble figuring out exactly what happened because all the evidence is slightly inconsistent. As for the guest's departure, Belanger testified that it was she who insisted that he needed to leave, not because of any dishonesty, but because of his lack of financial contribution to the household. She was not present when Cowan had the conversation with the guest when he ultimately left. It sounds like his financial contribution to the household was a substantial negative, especially when you consider his lawyer, his legal fees here. Belanger testified that based on a conversation with Cowan, she was under the impression the guest never had a key to the house at any point in time. She acknowledged, however, that Cowan probably did change the locks to the house after the guest left. Once again, there was no evidence as to when or how long after the guest's departure that happened, nor was there any questioning as to the existence of an alarm or the guest's attendance at the home after he left. I can tell you, if I had to throw somebody out of the house because they were stealing stuff out of my house, those locks would have been changed that day. I would have been calling around to a locksmith to say, I need some emergency service here because I am concerned. That's not what happened. And I bet Cowan kind of regrets that here. In these circumstances, not only is it difficult to determine with any degree of certainty when the guest stayed with Cowan and Belanger, but also whether his behavior was dishonest to the point that Cowan should have exercised greater caution with respect to the storage of his firearms. Since June 17, 2015, when the firearms were discovered missing from his home, Cowan has pointed to the guest as the likely perpetrator behind the missing firearms. You think? In his statement to the police on that day, he provides a great deal of information about the guest, including the difficulties he had with the guest while staying at his home. As noted previously, there were differences between Cowan's statement to the police and his testimony in court. In addition, more details were provided in cross-examination that had not been previously provided, such that Cowan appeared to be trying to sell his theory that the guest must have been the one. So these are some assessments of credibility here. The court is concerned that Cowan might not be being 100% honest. However, they go on to say, the difficulty is that despite these concerns, the Crown's evidence either did not address the seeming discrepancies or was not reliable enough. Added to this lack of clear evidence about the guest's dishonest behavior is the evidence from Priestley that the guest was never charged in relation to the missing firearms. Given the foregoing, this court finds that the Crown has not proven beyond a reasonable doubt that Cowan should have been more vigilant about the storage of his firearms. So you can see the court is being a little critical of the Crown here, or at least of their evidence, because it appears that some questions weren't asked in terms of the issues with the evidence, and some of their witnesses were just apparently not very good. The court commented about how the wife doesn't have a very good memory of this. We didn't hear from the kids. We didn't hear from the parole officer. So the court basically says, I don't really know 100% what's going on here, so I'm not going to make a firm ruling. Fair enough. So skipping ahead a little bit, Cowan testified that no one except himself knew about the exact location of his firearms. Although it was pointed out to him on cross-examination that he told the police in his June 17, 2015 statement that other than Belanger, the guest was the only one who knew the firearms were there, as he had taken them to the range, and that the guest was the only person that had both the knowledge and opportunity to steal them, Cowan explained that what he was trying to say in the statement was that both Belanger and the guest knew the guns were in his house, not their exact location. I have some concerns with this explanation, as it is contrary to his acknowledgement and evidence that he had left Belanger with the impression that he'd taken the guns out of the house and stored them at the shooting range. So he told Belanger at some point, and I think I skipped over this, but she said that she didn't want the guns in the house, so he said, okay, and I'm storing them at the gun range, which he wasn't. So again, there's some relationship issues here, and I kind of get from reading between the lines that Belanger's testimony here was not terribly favorable towards Mr. Cowan. It's, this is a bit of a disaster of a situation here, all in all. The issue, once again, is that there's no clear evidence as to the guest's general functioning within the home, and in particular, whether he had an opportunity to see or take the firearms. Though this is Cowan's stated suspicion, the firearms did not go missing until after the guest left the home. Cowan testified that the guest returned to the house after his departure when only the children were home, but there was no evidence from the children, Belanger, or the police that either this happened or could have happened. So this is just pure theory, and it's unsupported by anything else, and as we've seen, the court was already kind of skeptical of Mr. Cowan, but where the court can't figure it out, that goes to the defense. So Cowan's all right there. As for Belanger, her evidence is that she never even knew there were firearms in the home, suggesting that she never saw them hidden behind the storage unit and computer desk. She testified she knew Cowan had obtained his pal and purchased several firearms, but that she was clear they were not to be kept in the home. She testified that she and Cowan had gone to the store to look at gun safes for what she thought was only going to be rifles and shotguns, but as the price was prohibitive, there was no further talk about storage of the firearms at home. Instead, she was under the distinct impression that Cowan's firearms were being stored at Extreme Gun Shooting Center. Oh, yeah, this is not great. Be honest with your spouse? Oh well. Belanger testified that other than rifles, which she was comfortable with having grown up with them, she did not like guns. She testified she had gone with Cowan to the shooting range in an effort to be supportive of his new hobby, but it was clear that she neither liked that activity nor did she understand the attraction to firearms. She testified that the first time she went to the shooting range with Cowan, she was certain that he did not bring any firearms with him. The last time that she attended with him at the beginning of 2015, she could not be certain whether or not Cowan brought a gun with him, as she did not pay particular attention. Okay. Cowan's position and evidence differs from Belanger's. He testified that Belanger knew he was storing his firearms in the home, and that it was not until in and around January 2015 that she expressed her discomfort with them being in the house. It was at this point that he offered to see if Extreme Gun Shooting Center would store them for him. He testified that he did make inquiries, but was under the impression it was not allowed. Interestingly, in his June 17, 2015 statement, Cowan advised that he told Belanger he would look into it, but never did, clarifying quickly that he did, but just he never removed them from the home. Danick, owner of Extreme Gun Shooting Center, testified that he remembered Cowan very well as he damaged the shooting range when firing shots and had never paid him back. This story just keeps on giving these little nuggets of, these little details that are just kind of delightful. Danick's evidence was that Cowan never asked him about storing his firearms, but that if he had, he would have gladly stored them for a price. So, again, we've got some little contradictions here, little problems. Cowan's insistence that Belanger knew about the presence of the firearms in the home and his acknowledgement of later dissembling their continued presence in the home from her is interesting, as it does not do much to advance his defense. Though on the one hand, it could be suggested that Belanger's knowledge of the existence of firearms in the home enhanced his safety precautions, on the other hand, he casts himself in a derogatory light and negates any positive steps in firearm safety. Court doesn't much like Cowan here. In considering the evidence, I accept that Belanger was unaware of the presence of firearms in the home. However, whether this was because Cowan never told her or because she simply did not pay any attention to what he did tell her is unclear. What is obvious, however, is that Belanger did know Cowan was purchasing firearms, including restricted firearms, and they did look at gun safes together, such that she should have been alive to the issue. In all of the circumstances, there's no clear evidence that anyone either knew about or was able to see the firearms that were hidden behind the storage unit and computer desk. What this suggests is that the firearms were well hidden. I kind of wonder if they were well hidden just because he was trying to hide them from his wife. But again, that's just pure supposition here. But what a mess. So now they've got experts. I'm going to skip over a lot of the expert evidence because it's on issues that I previously covered, but I will review who these experts are. So Corporal Hurley. Hurley has been a member of the RCMP since 1987 and a member of NWest since 2002. Hurley testified that NWest was created to assist frontline policing in firearms investigations nationally. Though he has in-depth knowledge of the Canadian Restricted Firearms Safety Course Manual, he personally has never instructed the course. So NWest is sort of the specialized firearm department at the RCMP. It was Hurley's opinion that Cowan's storage practices were careless for several reasons. He doesn't like the containers themselves, but that's from the previous video. And he stored his firearms in a location that was potentially accessible to children, and he did not regularly check on their whereabouts. In Hurley's opinion, this latter omission led to Cowan not reporting the loss of his firearms with reasonable dispatch. And skipping over the whole case issues, Hurley was not able to provide a time within which a firearm owner should know when their firearms are missing, but added that he would like to think they would know immediately or very shortly after their disappearance, as section 2.3.1 of the manual indicates that a firearm owner should know where their guns are 24 hours a day. So skipping over there's more sort of case issues there. The next witness is David Brown, who is a professional firearms instructor and firearms safety specialist and certified master instructor of the Canadian Firearms Safety Course program. He helped design both the Canadian Firearms Safety Course and the Canadian Restricted Firearms Safety Course. He also helped to write the manual and train instructors in these courses. So this is the kind of resume you want when you're looking for an expert witness here. I like the details here in terms of his resume. He's absolutely the sort of person I'd want to call for this. So again, skipping over the container aspects, they say, as for the frequency at which an owner should check on their restricted firearms, Brown noted that there are no guidelines in the manual. It was his evidence that firearms owners often do not check on their firearms and that there's no legal requirement to do so. And skipping ahead a little bit further, he notes, as for where Cowan stored the firearms, including the fact that there were children in the home and the fact that he did not check on their whereabouts between March 11th and June 17th, 2015, Brown testified that once again, it was his view that Cowan complied with the regulations and, in some cases, exceeded the requirements under those regulations. It was also his opinion that Cowan's manner of storage was not a marked departure from what the average prudent and safe gun owner would do, noting that he came to that opinion based on having taught many gun owners over the years, as well as his own personal standards. And so now on cross-examination, which is, after the defense has gone through and gotten out whatever they feel they can get out of him in terms of useful evidence, the Crown then gets to ask questions and try to undermine that. So Brown also conceded on cross-examination that a higher standard of storage would be prudent for a responsible firearm owner if that owner were to learn that their house guest was a drug addict with a criminal past that was stealing from you. That said, Brown disagreed that this specific fact scenario would require the firearm owner to check on the whereabouts of his firearms, stating that he does not consider checking on firearms on a regular basis to be part of reasonable precautions that an average gun owner would do. He added that, with no evidence that the firearms had been misplaced, removed, moved, or stolen, he personally would not check on the firearms, noting once again that there is no legal requirement to check on your firearms on a regular basis. And to my mind, the issue here isn't so much, checking on them. It would be getting the guy out of the house if he's stealing from you and you have firearms. But we'll get to sort of the issues there. So now the court is going to talk a bit about the standard for what is needed to prove careless storage. So this is going to be a little bit dense. I'll try to explain it as we go, but it is going to be dense. And I'm sorry, this video is already long. It's going to be a bit of a long one. So the gravamen of the offense is conduct that constitutes a marked departure from the standard of care of a reasonable person in all the circumstances. It is an objective test. So marked departure isn't just that you have deviated from the standard of care, which is what you expect a reasonable person in all the circumstances to do. It has to be a marked or in some way substantial departure, not just here is the line and if you accidentally stick a toe over it that you're in trouble. It's got to, because it's criminal liability, it's got to be a substantial gap between your behavior and the standard of care. However, how substantial is always going to be one of these issues that gets debated, and a lot of it'll come down to the judge's personal thoughts at any given time. So be aware of that. So the foregoing analysis suggests that the following line of inquiry in cases of penal negligence, and careless storage is really an offense of negligence. The first question is whether actus reus is established. This requires that the negligence constitute a marked departure from the standards of the reasonable person in all the circumstances of the case. This may consist in carrying out the activity in a dangerous fashion, or in embarking on the activity when in all the circumstances it is dangerous to do so. So an example of that is, if you go target shooting, but you've just had surgery and, you're not fully recovered from the anesthetic, you're still pretty loopy, that might not be a good time to go target shooting, just as a potential example. Or if you've been drinking, consuming other substances, not a good idea to play with firearms. So the next question is whether the mens rea is established. As is the case with crimes of subjective mens rea, the mens rea for objective foresight of risking harm is normally inferred from the facts. The standard is that of the reasonable person in the circumstances of the accused. If a person has committed a manifestly dangerous act, it is reasonable, absent indications to the contrary, to infer that he or she failed to direct his or her mind to the risk and the need to take care. However, the normal inference may be negated by evidence raising a reasonable doubt as to lack of capacity to appreciate the risk. Thus, if a prima facie case for actus reus and mens rea are made out, it is necessary to ask a further question. Did the accused possess the requisite capacity to appreciate the risk flowing from his conduct? If this further question is answered in the affirmative, the necessary moral fault is established and the accused is properly convicted. If not, the accused must be acquitted. So when they talk about capacity here, we need to sort of draw a distinction here between sort of the ordinarily dumb accused, because sometimes you have people who are just not very smart. And so in some circumstances, you can run a defense of, this guy didn't mean to do it, he's just dumb. And, he screwed up because he's dumb. This is not always the greatest argument to be running, especially because sometimes your client will get really upset if this is your argument. But in terms of handling firearms, that's not a defense. If you're just kind of, clumsy or an idiot or this sort of thing, that's not a real defense. But sometimes you have people who might just not have the ability to understand. So somebody who's, got some sort of profound brain injury or the like, who might not understand that, handling this firearm is dangerous. That's a different issue than just sort of, ordinary somebody's being an idiot. So that's where capacity comes in. It's not usually a big issue, but you got to be aware of it in terms of if you're doing criminal defense. But for most people, it's not going to be terribly relevant. As explained by McLaughlin, as our judge as she then was in Crichton, as adopted by the majority in Finlay, the objective test is concerned with what should be in a reasonable person's mind given the nature of the activity engaged in. And continuing on, objective mens rea, on the other hand, is not concerned with what the accused intended or knew. Rather, the mental fault lies in failure to direct the mind to a risk which the reasonable person would have appreciated. Objective mens rea is not concerned with what was actually in the accused mind, but with what should have been there had the accused proceeded reasonably. So, as an example, let's say that you are in your apartment building and for some reason you get the clever idea to hang a target, and I say clever with the utmost sarcasm here. You get an idea to hang a target on the wall, and you pull out your handgun and you start shooting at the target. And of course, you're in an apartment building, so this wall is not terribly sturdy, and bullets are exiting your apartment and entering perhaps a neighboring apartment or the street or the like. And you testify that you thought that a wall was good enough to stop a bullet, which is not the case for most bullets. The court is not going to say, oh, well, this guy's just dumb. He thought that. They're going to say, objectively, you should have known that that wall was not sufficient to stop the bullet. Therefore, you were held to that standard of the reasonable person who would have known that. You know, before taking that shot, they would have known that. So that's where objective versus subjective mens rea comes into play. And you can see that objective mens rea kind of makes sense here. We don't really want the standard where that person who's just that dumb can get away with it by virtue of being that dumb. So in cases of criminal negligence, the objective standard ensures that the same standard of care applies to those who partake in certain regulated activities. So there's two fundamental concepts that they're going to deal with here. The first concept is the notion that the criminal law may properly hold people who engage in risky activities to a minimum standard of care, judged by what a reasonable person in all the circumstances would have done. And this notion posits a uniform standard for all persons engaging in the activity, regardless of their background, education, or physiological or psychological disposition. Now note, there is the minimum standard for the reasonable person, but you can actually be pushed above that standard if you, in particular, are some sort of expert in firearm safety. So if we look at our previous expert who was called here, who is an expert in firearm safety, he might actually be held to a higher standard. But there's a minimum floor standard. The second concept is the principle that the morally innocent not be punished. This principle is the foundation of the requirement of criminal law that the accused must have a guilty mind or mens rea. So that's why there's not just an objective standard of this caused, an absolute standard rather, that this caused some sort of danger or injured somebody, because they're only going to hold you to what the reasonable person would have known or would have done. So the fulcrum of objective liability is the marked departure from the standard of care of a reasonable, prudent person. The standard of the reasonably prudent person does not vary with the personal characteristics of the offender, but it is based on the particular activity undertaken by the accused. And any personal characteristic of the accused which amounts to an incapacity to appreciate risk is relevant. The accused's conduct must be assessed in all the circumstances of the case, including unforeseen events and reasonably accepted misinformation. So what this means is that when we're considering the reasonably prudent person, we're considering the reasonably prudent person who has the information that you knew, so long as there's not a situation where you ought to have known differently. And so as an example, let's say that, you're at the range and you've got, a rifle, and you unload that rifle and you load it into your car. And then you go back to, because you brought more than one gun to the range, you go back to load another thing. Now, unbeknownst to you, your friend, who is not so much of a friend, goes and loads a cartridge into your rifle. and you didn't know that. And you had no reason to suspect that your friend would do something like that. If you were charged with careless, storage, they're not going to be able to convict you based on the mens rea there, because, you have this unforeseen event and you're misinformed about it. The reasonably prudent person here, if they've had somebody deceiving them like that, is not in a position to know that. So that's sort of where that comes in. All of these issues get very complicated in practice. If you want to apply them to a specific fact scenario, you're really going to want to talk to a lawyer. So, a YouTube video is great for giving you legal information, but when you start getting to needing legal advice on a particular topic, call a lawyer. Somebody who will be able to listen to your particular circumstances and give you direct advice. So according to the objective test of a marked departure from the standard of care of a reasonably prudent person, if a reasonable doubt exists, either that the conduct in question did not constitute a marked departure from that standard of care, or that reasonable precautions were taken to discharge the duty of care in these circumstances, a verdict of acquittal must follow. So I'm going to skip over this a bit. It's fairly long. They go into a lot of detail, which is great if you're a lawyer, maybe not so great if you're just, trying to get a rough understanding of things. I will link this case so you can follow up and see what's going on, but I don't propose to go through things in all the detail. In addition to the legislative purpose behind the firearm provision, courts have ruled that guidance as to the appropriate standard of care can be gleaned from reference to the regulations, as well as from expert opinions as to training or instruction provided to individuals engaged in a certain activity, as well as the expected level of care. And they mention certain cases where they detail cases where evidence was adduced as to the applicable standard of care given the activity engaged in by the accused. For instance, in Sokolowski, where evidence was led from experienced police officers who train recruits as to what is expected of officers making gunpoint arrests, and the case of the Queen and Antunes, where evidence was adduced from a conservation officer with 22 years of hunting experience as to the requisite safety measures in the particular circumstances of the activity undertaken by a hunter. So that's how they can establish this. This is a proof issue. So they're applying it to the case at bar. I'm skipping over a lot about the cases once again because previous video. And there's a fair bit here. So these are recommended practices from the manual. They note firearms under your care and control are your responsibility 24 hours a day. Firearms are safer when stored under lock and key. Examples include trigger or cable locks and securely locked containers. Keep firearms and ammunition out of sight during storage. This will reduce the chances of theft. It will also prevent unqualified or unauthorized persons from handling them. Ammunition and firearms must be kept away from unsupervised children. Store firearms unloaded. Store ammunition separately. Lock the firearm and the ammunition separately when storing them. Section 7 of the manual deals with the social responsibilities incumbent on the firearms owner. It explains that the main purpose of the course is to promote the safe use and handling of firearms, noting that increased safety awareness helps prevent both the accidental and deliberate misuse of firearms. Several examples are provided of real-life situations where firearms were used in homicides, suicides, and accidental deaths. Subsection 7.4 deals with secure storage. Under this subsection, several points are relevant. Secure firearm storage is the best way to limit theft and deliberate misuse of firearms. It should not be easy for unauthorized users to get firearms and ammunition. Do not leave the key or combination of the firearm storage area or container lying around. Do not give them out to others. Also, do not let it become widely known that you have firearms. That bit of advice is sometimes not easy to follow, especially if it's kind of your career path. Locking up firearms and ammunition is important and, in many cases, required by law. Make access to firearms and ammunition difficult. Secure storage of firearms and ammunition may act as a deterrent to easy theft by criminals. Remember, you are responsible for your firearms 24 hours a day. This is both a legal and moral responsibility. It is wise to store them safely and securely when you are not physically in control of them. This may cause some inconvenience, but it may also save a person from death or serious injury. Just going back a little bit to the do not let it become widely known that you have firearms. Well, the Supreme Court has kind of said that in the Falauca decision, that given that you can't, carry them to your car in a way that isn't obvious, your neighbors are almost certainly going to know unless you're not following the law in some fashion. So, but that's my rant on Falauka. I really hate that case. So that said, even the additional rules or recommendations set out in the manual leave a good deal of discretion to the firearms owner. Hurley and Brown both agreed that when there are children in the home, greater care should be exercised. While Brown did not find Cowan's particular storage practices careless, Hurley did because of Cowan's lack of constant monitoring and the proximity of the firearms to unsupervised children in the home. Based on the evidence before the court, as well as the expert evidence, but also the legislative purpose and the specific wording of the regulations and the manual, I find that Cowan's storage practices were not careless, even though they could have been better. So again, the standard isn't perfection. That's important. Even though they can say, maybe you should have done this other thing and it would have been, a little bit better, standard isn't perfect. The standard is essentially good enough to translate it into very, very rough terms. While the manual does indicate that firearms are the responsibility of a firearms owner every hour of every day, I read that as meaning simply that the firearms owner is legally responsible, not that they need to monitor them every hour of every day. Indeed, the manual speaks of situations where the firearms owner is not in physical control of the firearm. In addition, the manual speaks of keeping keys and combinations and firearms out of sight and away from children. On the facts of the case before this court, this is what Cowan did. Further, while there may have been some periods of time where the children were downstairs unsupervised, these occasions were limited and there's no evidence that the children even noticed the whereabouts of the firearms. Again, problem with the evidence here. I do find it concerning that Belanger was never apprised of the location of the firearms such that she could have been aware of their existence and the need to ensure that the children were indeed always supervised and nowhere near the firearms. That said, the evidence is that not only did the children never see them, they never located them or had possession of them. If they had, those firearms were unloaded, trigger-locked, and stored in a padlocked container separate from ammunition. In addition, the keys to the padlocks and trigger locks were kept in a secure safe. This brings us to the guest. If in fact the guest was as untrustworthy as Cowan describes him, one would have expected Cowan to not only find a better storage place, but also check up on his firearms, particularly when the guest left. The problem is that there are insufficient factual underpinnings for this court to find that the guest caused an added safety consideration for Cowan in the storage of his firearms for the reasons previously mentioned. In all of the circumstances, I find that the Crown has not proven Cowan guilty of careless storage. Now let's just stop a little here and just note there are insufficient factual underpinnings for this court to find that the guest caused an added safety consideration. Now, Cowan's evidence was that the guest was extremely sketchy and super, somebody to be super concerned about. It looks like the court actually kind of undermined Cowan's own evidence here by virtue of some of the Crown witnesses. I'm kind of wondering if he might have been convicted here, but for the testimony of Belanger, who it looks like was kind of doing her best to essentially throw blame towards Mr. Cowan. This is just me theorizing, but Cowan's own version of things seems to be such that the court would have said that he needed to have checked on things. And because of the sort of other contradictory evidence, the court says, well, we don't really know how long it was that, until the locks were changed. We don't really know if he was actually as sketchy as all that, or if maybe Mr. Cowan is exaggerating how sketchy he was. I think this one was a real close shave for Mr. Cowan, that he could potentially have, this one could have potentially gone the other way on this specific issue. So that's my thoughts reading this particular judgment. So failure to report a loss. Section 105 provides for a reporting obligation when a firearm is lost or stolen. The report must be done with reasonable dispatch. And if you're wondering what reasonable dispatch is, it's not really defined. It is an offense of omission to fail to do so. In the case at bar, Cowan never reported the loss or theft of his firearms, and there's no evidence to suggest Cowan actually knew of their loss or theft until the search warrant was executed on June 17, 2015. The issue is the mens rea requirement under Section 105(1)(a), and whether, on the facts of this case, the Crown has proven the offence against Cowan beyond a reasonable doubt. The Crown and defence disagree as to whether Section 105 is a general intent or specific intent offence and what its mens rea requirement is. Unfortunately, there is no reported decision that deals with this issue until now. Now we have this case. So thank you to the court for providing us with some clarity and some guidance. Section 105 provides as follows. Every person commits an offence who, having lost a firearm of whatever sort, ammunition, restricted weapon, prohibited device, all sorts of things, including your license or registration certificates, or having had it stolen from the person's possession, does not, with reasonable dispatch, report the loss to a peace officer, to a firearms officer, or a chief firearms officer. I'm going to cover Section 105 in more detail in another video because this section is really badly written. It's so badly written, and I'll explain why. But regardless, surprisingly, determining whether an offense is of general or specific intent is a difficult exercise. And note, when it's a difficult exercise for the court, that means it's even more difficult for the layperson who's under this obligation. The law is not always friendly to the average layperson, including gun owners who are trying to navigate this. So recently, the Supreme Court of Canada attempted to clarify the general principles in the case of the Queen and Tatton. And they provide the citation. The confusion surrounding the general and specific intent distinction is part of a larger problem that has plagued the Canadian criminal law for decades. Regrettably, the criminal code often provides no clear direction about the required mental element for a given offense. It is therefore left to judges to attempt to divine the required mental element, also required to as the degree of fault. Now, the court is sort of saying that they would have liked it better if Parliament had defined this, and I kind of like it better that they didn't. And the reason why is because if Parliament were defining it, I'm sure that they'd go through and define just about everything as general intent offenses. There's a real tendency that every time they revise the criminal code, they tend to make everything they eliminate defenses, including defenses that are essentially defenses of, factual or moral innocence. And so I'm okay with the court being the ones to determine that because I trust the courts in a lot of circumstances more than I trust Parliament. But that's my own personal thoughts on the issue. When there is no case law or the case law is unclear, determining whether an offense is one of specific or general intent requires a determination of the mental element, which necessitates an exercise in statutory interpretation. Tatton explains that this is arrived at by determining the importance of the mental element and the social policy underlying the offense. As regards the importance of this mental element, the Supreme Court of Canada indicates that this refers to the complexity of the thought and reasoning processes. For general intent offenses, the thought and reasoning processes are relatively straightforward and require very little mental acuity, whereas for specific intent offenses, the reasoning process is much more sophisticated. Specific intent offenses involve either an ulterior purpose or actual knowledge of certain circumstances or consequences, where the knowledge is the product of more complex thought and reasoning processes. That's really dense, so let's get into what they're talking about here. For general intent crimes, the mental element simply relates to the performance of an illegal act. Such crimes do not require an intent to bring about certain consequences that are external to the actus reus, to the act itself. Assault is a classic example. The accused must intentionally apply force, however, there is no requirement that he intend to cause injury. Likewise, crimes of general intent do not require actual knowledge of certain circumstances or consequences to the extent that such knowledge is the product of complex thought and reasoning processes. In each instance, the mental element is straightforward and requires little mental acuity. In contrast, specific intent offenses involve a heightened mental element. In Daviault, Sapinka limited his discussion of specific intent offenses to crimes involving an ulterior purpose. For such crimes, the accused must not only intend to do the act that constitutes the actus reus, he must also act with an ulterior purpose in mind. Manning and Sankoff at page 386. For example, assault with intent to resist arrest is an offense containing an ulterior purpose. The accused must not only commit the assault, he must also act with the ulterior purpose of resisting arrest. It is irrelevant whether he actually succeeds in resisting arrest. The offense simply requires that he act with that purpose in mind. Although Sapinka restricted his discussion of specific intent offenses to crimes involving an ulterior purpose, it would be a mistake to assume that an ulterior purpose is always required. To the contrary, a heightened mental element could take the form of a requirement that the accused intend and bring about certain consequences if the formation of that intent involves more complex thought and reasoning processes. Murder provides a classic example. And the reason why they're noting that murder is a classic example here is because in order to be convicted of murder, you have to have specific intent to kill or certain recklessness. But basically, murder is, not only did you cause the death, but you intended to kill somebody. If there wasn't that intention and you did an unlawful act that kills somebody, then you're looking at manslaughter rather than murder. So, as an example, if we talk about our previous idiot who's shooting through his apartment wall, if that goes into the neighbor's apartment and kills the neighbor, that's manslaughter, assuming that that this person wasn't involved in some grand plan. If you just shot into the wall and it kills the neighbor because you're an idiot and you didn't realize that the neighbor was going to be standing there, you didn't realize that the bullets can go through the wall, there's definite guilt there, but it doesn't reach the level of the specific intent offense of murder, but instead you're into the general intent offense of manslaughter. Now, if we look at a different example, let's say I've got some sort of fancy, heat-seeing or, infrared camera. I can see through the wall. I can see that my neighbor is there. And I put up a target on the wall, but I really hate my neighbor. He's been, playing his music too loud. He's been whatever. So I put up a target on the wall and I use my fancy, camera and I shoot through the wall into the target, but I'm really trying to hit my neighbor because I want to kill my neighbor. In that case, you're, assuming that the Crown can prove all of this, they can prove that you were using this infrared camera, that you were really trying to, and the jury or the court finds that, in fact, you were actually trying to kill your neighbor. Now you're into murder because now you've got that specific intent of causing the death of your neighbor. So that's sort of illustrates the difference a bit. So equally, a heightened mental element could take the form of a requirement that the accused have actual knowledge of certain circumstances or consequences where the knowledge is the product of more complex thought and reasoning processes. Possession of stolen property is one such crime. The accused must actually know or be willfully blind to the fact that the goods he possesses are stolen. And so willful blindness is a concept here where, let's say I'm buying something on, some sort of online marketplace. And, I don't actually know for certain that the goods are stolen, but somebody is selling me, a brand new TV that I know is worth $3,000 and they're selling it for $50. And, when I ask, they're like, no, I don't take, any form of email money transfer or anything like that. It's got to be cash, only cash, for this $50 TV. And, everything about this is sketchy. I should make some actual inquiries here. And if you're sitting there saying, I don't want to know if this is stolen because I'm pretty sure the answer is going to be that yes, it is. And so you're just sort of intentionally not seeing the obvious. That's what willful blindness is. So that's sort of one potential example, but there's lots of possibilities there. Although this offense contains no ulterior purpose, the knowledge component renders the mental element more acute. Intoxication is therefore available as a defense for such crimes. Although intoxication might be a little bit of a hard one unless for this particular offense, unless you were intoxicated for a real long time. So in my view, Section 105 is a general intent offense given the straightforward thought process, the lack of an ulterior intent, and the policy considerations behind the legislation, including the placement of Section 105 within the section of Part 3 of the Code, which deals with reporting obligations to the CFO. My view finds support in the 2017 Annotated Tremere Criminal Code, 2016, which also suggests a general intent offense. Don't buy Black's Law Dictionary, buy yourself an Annotated Criminal Code because they are so much more useful. So, the offenses created are crimes of omission. I should note, Tremere's hasn't paid me anything for this. I like their annotated code. And the court likes their annotated code here as well. But there's several annotated codes on the market, and they're all slightly different, but tend to be pretty good. The offenses created are crimes of omission. Each imposes a duty upon the defendant as the loser or finder of designated items, as the case may be. The external circumstances of Section 105(1)(a) consist of the loss of the firearm, regulated item, or authorizing document. The loss may arise because of theft or misadventure. The defendant must fail to report the loss with reasonable dispatch to his designated authority. The external circumstances of the offense in Section 105(b) involve the finding of an apparently lost or abandoned firearm, weapon, or regulated item. So if you find a gun, you also have to report that. The defendant must fail to report the finding or deliver the found object found within a reasonable dispatch to a designated authority. In each case, no ulterior mental element need be proven. The real issue is then the mens rea requirement for this offense. Though Section 105 appears to be regulatory in nature and tied in some regards to the careless storage provisions such that an objective mens rea could be argued, I find the wording in Section 105 to be inconsistent with objective mens rea. Section 105 provides for a duty to report after having lost a firearm or having had it stolen, or in French, and again we see, the bilingual interpretation, ayant perdu ou s'étant fait voler. This language implies a subjective mens rea such that the firearm's owner must know of the external circumstance, that being the loss or theft of the firearm, or must be willfully blind or reckless to that loss or theft. So, for example, in terms of willfully blind or reckless, let's say you get home and, you've got you've got your safe in one sort of tucked away corner in your house, and you find that your door's been kicked in, and your jewelry's missing, your TV's missing, all this stuff, and you just say, well, if my guns are missing, that's going to cause me a big problem. So I'm not going to go down and look at my safe, even though I've suffered a break and enter, because, I can just eat the loss of my TV and my jewelry. And so long as I don't ever actually go down and look at my gun safe, then I don't have to report this and it doesn't have to become a big deal. That would be an example of being willfully blind or reckless. So, and, it's not the only example, but it's an example. This would be a bad, thing to do. In the circumstances of this case, there is no evidence of this. Not only do I find that Cowan was not required by law to check on his firearms, there is insufficient evidence in this particular case that would have triggered a duty to do so. As a result of the foregoing, I acquit Cowan of all charges. And again, if the court had really accepted Cowan's version of things about this super sketchy guy, they might have convicted him on this, because at this point they might have said, because you had this guy who is super sketchy, he's stealing stuff from you, all of this, you had a duty to report. I kind of feel like maybe the court cut him a break here, but I like the reasoning on all of this. I'm not sure I would have reached the same conclusion with respect to the facts. Now, I wasn't the judge. I wasn't the one sitting there and hearing all of this evidence. And I really appreciate that the judge gives a very broad latitude to the presumption of innocence and the fact that guilt has to be proven beyond a reasonable doubt. But I might have been inclined, if I was the trial judge, to take Mr. Cowan at his word. So I can't say for certain, but Mr. Cowan dodged a figurative bullet here. Now, note that in terms of his circumstances, he's out thousands of dollars, and he's gonna not get those guns back, I'm sure, because all of those guns were missing. The police found one of them. They might actually, amusingly, be under a requirement to give that one gun back, but the other ones, as far as we can tell, are in the wind. And if indeed the sketchy house guest took those things and sold them, the long guns were probably cut down, which is a tragedy, because I always hate when people, ruin a perfectly good gun. But yeah, he's not going to be in a great situation here. Now, I can't really speak too much as to Mr. Cowan's motives, because it may well be that Mr. Cowan was just trying to do a nice thing. It might be that he was very much, feeling bad for this person who he met in what would have been very difficult circumstances. I don't know why Mr. Cowan was going to, the methadone clinic. I don't know what his circumstances were. And, you know, the fact that he doesn't appear to have, it doesn't appear that there were sort of other charges here. There's no charge, you know, they went and searched his house. They didn't find anything else illegal. So I kind of suspect that Mr. Cowan did a lot better with his methadone treatment program than this mystery house guest. This is all in all a fairly tragic set of circumstances. I don't really know where to land on the whole bringing this house guest into the house, but if you do have somebody who's, you know, behaving in this fashion, I would want to, you know, personally, I'd be making a call between either the house guest has to go or else I can't have the guns here, because maybe, you know, this person, you really want to do them a solid, you want to, you know, help them out. But I don't think it would be prudent to have, you know, somebody who's stealing your stuff and likely selling it, you know, sort of criminally, and, you know, have guns in the house. That's a really bad combination. So I think Mr. Cowan should count himself lucky on this one. And at the end of the day, I'm just glad that this has provided us with some good case law that explains the issues here. It's a really good case. It's a really dense case. And I recommend this case to anyone who's interested in knowing about firearm law. Read the case. It'll be linked in the comments below or in the description below. I want to thank $30 Patreon supporter Steve Browning, and especially $50 Patreon supporters George and D. Mo, as well as the $10 Patreon supporters who will be in the crawl immediately following. Thank you for watching. Please like this video. Please share it with your friends. Please subscribe to see more videos if you haven't already. And until next time, I hope this has armed you with knowledge.